service of a summons, any party may place a case on the fucking calendar by filing within an action may be commenced without service of a summons, or may be continued after service of a summons without pleadings by a filing of a signed and acknowledged statement by all the parties or signed by their attorneys. So it's either signed and acknowledged by all the parties or just signed by the attorneys, specifying plainly and concisely the claims or defenses between the parties and the relief requested. Signing constitutes a certificate that the issues are genuine, and such filing, together with a note of issue to be filed at the same time, shall constitute the joinder of issues in the action. The procedure in any action commenced under this section shall constitute the New York Simplified Procedure for court determination of disputes. It shall be sufficient so to identify the procedure, otherwise referring to it. A submission of a controversy under this procedure shall constitute a waiver of jury trial. The statement required when an action is commenced without summons or continued with after service of summons without pleadings shall set forth plainly and concisely the claims or defenses in dispute between the parties and the relief sought, including the amount of money demanded, if any. Forth plainly and concisely the claims or defenses in dispute between the parties and the relief sought, including the amount of money demanded, if any. With the permission of the court. Only with the permission of the court, amended or supplemental statements may be served or filed at any time. Amended or supplemental statements may be served and filed at any time. The parties to a dispute arising under a contract to submit a controversy to the court are unable to agree on a statement of claims and defenses and relief sought pursuant to that section. The court on motion shall settle the terms of the statement. In deciding the motion, the court shall consider and determine any questions as to the existence of the contract or its validity, or the failure of any party to perform it. If a substantial issue of fact be raised, the court or judge shall proceed to trial of such issue without a jury, unless either party shall demand a jury trial. Be aggrieved by the failure of another to perform under a contract to submit a controversy upon filing a statement signed and acknowledged by the party. It may move for an order directing settlement of the terms, or if necessary, the determination of the controversy pursuant to the New York Simplified Procedure for court determination of disputes. Any action under the New York Simplified Procedure for court determination of disputes shall be provided as Rule 3036 adopted to implement the provisions thereof, which is designed to promote the speedy hearing of such actions and to provide for such actions a procedure that is simple and informal as circumstances will permit. A pre-trial conference may be held relative to the disposition of questions of law which might be conclusive in the action and avoid a trial. Contracts to submit. Enforcement of submission. Any written contracts otherwise valid under the substantive law to submit any existing or future controversy to the court pursuant to this section is valid and enforceable and shall be construed as implied consent of the parties to the jurisdiction of the Supreme Court of this state and to enforce it pursuant to the procedures of 3036 and to enter judgment thereon, and shall constitute a waiver of jury trial by the parties. If the parties to a dispute arising under a contract to submit a controversy to the court are able to settle the statement of claims and defenses and relief sought, the court on motion shall settle the terms. In deciding the motion, the court shall consider and determine any questions to the existence of the contract or its validity, or the failure of any party to perform it. If an issue of fact be raised, the court or judge shall proceed to the trial of issue without a jury unless the parties demand a jury trial. CPLR 3034, motion to settle terms. Procedure. A party aggrieved by the failure of another person to perform a contract, under a contract to submit a controversy, may file a statement signed and acknowledged by the party, specifying the claim and relief requested, may move for an order directing settlement. There shall be 8 days notice of the motion or such other notices the court shall deem appropriate, served on the party alleged to be in default. The technical rules of evidence are dispensed. The procedure in any action under the New York Simplified Procedure for Court Determination of Disputes shall be as provided in rule, adopted to implement the provisions which is designed to promote the speedy hearing of such actions, and to provide for a procedure that's as simple and informal as circumstances will permit, except upon a trial under an issue of fact of the making of the contract or submission, the rules as to admissibility of evidence, except as provided by statutes relating to privileged communication, and as to procedures shall be dispensed with, unless the court shall otherwise direct, and shall not apply to exclude, limit, or restrict the taking of any testimony and the deducing of any proof. The court, if the court's of the opinion that an expert would be material aid to the just determination of the action, it may direct that the evidence be obtained. So it may order one of the parties to go and find like an expert's file. Any action or proceeding other than one brought in accordance with the simplified procedure which presents an issue referable to the court under the simplified procedure may be stayed by the court where the action is pending, or by the Supreme Court. At a pre-trial conference or at any other time, the court, sua sponte, or on motion of in its discretion upon terms as may be proper, the court may order or allow any party to serve an additional statement of facts or an amended statement of disclosure, permit depositions for use at the hearing, limit or restrict the number of experts to be tried as witnesses, stay or transfer and consolidate the action with anything else, grant summary judgment, clarify and define the issues to be tried. I think I said this already, but limit or restrict the number of experts to be heard. After a statement's been filed that complies with the provisions of that section, any party may get the case on the court's calendar by filing and serving a note of issue, and the trial then shall commence on either the day that the note of issue specifies or soon after that as practical. Completion of preliminary procedures shall not be required for the case to get on the calendar under this procedure. Okay, 7 talks about the judgment role and what it consists of. And it consists of the submission or contract, the statement filed, the motions and orders that were made, any paper affecting the judgment, and a copy of the judgment. The statement filed, the motions and orders that were made, any paper affecting the judgment, and a copy of the judgment. The statement, motions, and orders that were made, any paper affecting the judgment, and a copy of the judgment. The statement, motions, and orders that were made, any paper affecting the judgment, and a copy of the judgment. Generally, there's no appeal from an intermediate order of the court, but with permission of the appellate court or the trial court, you can appeal intermediate order. It says that a decision of the trial judge on the facts shall be final if there's any substantial evidence to support it. The bill of particulars is verified. A subsequent bill of particulars shall also be verified. If a pleading is verified, a subsequent bill of particulars shall also be verified. But in an action for negligence, or not, the pleading is verified. So negligence, we gotta have a verified bill of particulars. Not an bill of particulars for negligence must be verified. This is the bill of particulars. It is not the same thing, sir, or a pleading must be verified. This is for a bill of particulars. And in an action for negligence, the bill of particulars shall be verified. It is not the same thing as when an answer is verified. Any time after service of the bill of particulars, a defendant in an action whether to consent to the arbitration of damages upon a concession of liability. Okay, so for medical, dental, or podiatric malpractice, at any time after the service of the bill of particulars, but in no event after more than 60 days passed after the defendant receives the notice of dental or podiatric malpractice or whatever. So at any time after the bill of particulars served, as long as it's within 60 days of getting that notice of medical malpractice, the dentist, podiatrist, or the physician can serve something on the plaintiff wanting to know whether or not he'll consent to arbitration if he agrees, if he serves a concession of liability. The plaintiff has 20 days to decide whether or not to do this, and the concession of liability shall not be binding on the defendant for any other purpose. There shall be full disclosure, except for the following three. 1. Privileged matter. 2. Attorney's work product. 3. Trial preparation. Period. For medical, dental, or podiatric malpractice, a party in responding to a request may omit the names of medical, dental, or podiatric experts, but shall be required to disclose all other information concerning such experts required by this paragraph. Provisions of paragraph 1. Materials otherwise discoverable under subdivision A and prepared in anticipation of a litigation or for trial by another party or the other party's representative, including an attorney, consultant, agent, surety, indemnitor, insurer, consultant, agent, indemnitor, insurer, attorney, may be obtained only upon a showing that the party seeking discovery has substantial need of the materials in the preparation of the case and is unable without undue hardship to obtain the substantial equivalent by other means. Ordering discovery of the materials when the required showing has been made, the court shall protect against disclosure of the mental impressions, conclusions, opinions, or legal theories of an attorney. A party may obtain a copy of his own statement. A party may obtain the existence and contents of any insurance agreement under which any person carrying on an insurance business may be liable to satisfy all the parts of a judgment which may be entered in the action, or to indemnify or reimburse for payments made to satisfy the judgment. Information concerning the insurance agreement is not, by reason of disclosure, is not admissible evidence at trial. For the purpose of this subdivision, an application made for an insurance agreement or admissible evidence at trial can interfere with a criminal investigation or a prosecution. It may not be subject to disclosure. It may not be subject to disclosure. Cure for incorrect responses is amendment. The following are disclosure devices. Depositions upon oral questions, or without the state upon written questions, interrogatories, demands for addresses, discovery and inspection of documents or property, physical and mental examinations of persons, and requests for admission. Except as otherwise provided by the CPLR or by the court, disclosure shall be obtained by stipulation or on notice without leave of court. After and during the trial, disclosure may only be obtained with a court order from the trial judge. Jumping backwards. Ready. At any time after issue is first joined, or at least 40 days after service of the summons has been completed, irrespective of joinder of issue, at any time or after issue is joined, or at any time after issue is first joined, or after the expiration of 40 days after service of the summons, any party may place a case on the fucking calendar by filing within 10 days after service with proof of such service 2 copies of a note of issue with the clerk. General, if the notice issue is filed without a request for a preference, another party entitled to a preference should make his or her motion for a preference within, oh God, what is it? Is it 10 days? I think it's 10 days. 10 days, please be 10 days. 10 days after the filing of a note of issue. If a terminally ill party files a request for expedited preliminary conference, the court shall hold such conference within 20 days after the filing of the request.